Welcome to everyone who's joining us this Tuesday afternoon. It was great to see many of you in person at the Syracuse Workplace Seminar that was last Thursday. It's a pleasure to present to you on Tuesdays, but it's always nice to see your faces in person rather than staring at a webcam. So welcome, and let's get started. We have a packed program today. First off, I will do my COVID update. These seem to be getting better and better, which is good. Hopefully they stay that way. Right now, you can see that our test positivity, hospitalization numbers are down, ICU numbers are down, and case numbers are down. These are all good things. This is New York statewide. I know that there was a bit of a spike in certain counties in New York State a couple of weeks ago, but that seems to have subsided. Next slide, please. We see again good colors. We don't want to see the darker orange into red. We are not seeing much of that. You're seeing a lot of negative numbers in terms of cases. The positive numbers you see in the 14-day changes are okay because we're looking at daily cases in the teens and 20s. We're not looking at daily cases in the hundreds or thousands like we were. These are just smaller counties and the case numbers are much smaller. So good news on the COVID front. We'll continue providing that information as long as it seems to be relevant, and it still is for now. All right, next up, we have Subha Viswanathan. Subha is a partner in our Syracuse office. Subha is an expert on all things wage and hour law related. There have been some significant developments in the wage and hour realm, so I thought it would be good to ask Subha to come on. Subha also has written many articles for our labor and employment blog on these topics, so feel free to take a look at those as well. Subha, welcome.
Thanks, Adam. So the most important development, and the one that probably has the most general applicability, is that the minimum wage is going up by $1 in all areas outside of New York City, Nassau, Suffolk, and Westchester counties. That's all employees other than fast food employees. The minimum wage in New York City, Nassau, Suffolk, and Westchester counties is going to remain at $15 per hour. Remember that this is all going to be effective December 31st, 2022. I'm not sure why the state makes our minimum wage increases effective December 31st instead of January 1st. But it's important to keep in mind that if you do have minimum wage employees who work on New Year's Eve, it starts that day. It starts December 31st. Fast food employees across the state, the minimum wage is going to stay at $15 per hour. So there's no change to that. Next slide, please. Some of the other proposed changes that have more limited applicability are the changes to the tip credits. So hospitality industry, hotels, restaurants. If you have food service workers in restaurants, the tip credit is going to change. It's not going to change in New York City, Nassau, Suffolk, and Westchester counties, but in the rest of New York State, it's going to go up by 35 cents in the tip credit. So employers in the restaurant industry who have food service workers can now take $4.75 per hour as a tip credit, which makes the tipped minimum wage for food service workers $9.45. There is no tip credit that's allowed for fast food employees. Next slide, please. Service employees, so that's anybody who works in the hospitality industry other than food service workers. So, people in hotels who might get tips, such as bellhops, others. That the tip credit is also going to go up for service employees in areas outside of New York City, Nassau, Suffolk, and Westchester counties. It's going to go up by 15 cents per hour. So it's going to be $2.35 per hour as a tip credit. And the new tipped minimum wage for service employees in the hospitality industry is going to be $11.85 per hour. Next slide, please. There is a minimum threshold that has to be met in order to qualify someone as a tipped employee to be able to take the tip credit. So, just as a practical matter, if you're in the hospitality industry and you have tipped employees, you should have some sort of tip reporting mechanism on a week-to-week basis so that you can confirm that the people that you're taking a tip credit for meet the threshold to be considered tipped employees. The service employees at resort hotels in the rest of New York State, other than New York City, Nassau, Suffolk, and Westchester counties, an employee has to earn at least $7.95 per hour in tips in order to be considered a tipped employee, a tipped service employee. Service employees in restaurants and non-resort hotels, a person has to earn at least $3.05 per hour in order to be considered a tipped employee and to take the tip credit. Next slide, please. We don't have a final amount for what the administrative and executive exempt salary is going to be effective December 31st, 22, but we do have proposed regulations. The proposed regulations don't have any change to New York City, Nassau, Suffolk, and Westchester counties. The proposed regulations say that the exempt threshold is going to be $1,064.25 for employers outside of New York City, Nassau, Suffolk, and Westchester. That is an increase of $74.25 per week. Historically, the salary level threshold for the executive and administrative exemptions has always been 75 times the minimum wage. If you actually do the math, 75 times the new minimum wage of $14.20 actually comes out to $1,065. And I have no idea why the state decided that it's going to be 75 cents less than that, but that is the minimum salary that was proposed. Remember that the New York minimum salary levels for the exemptions, although they are much higher than the federal, they are inclusive of board, lodging, or other allowances and facilities. So if you happen to provide meals or lodging to an employee, you can count the value of that towards the minimum salary for purposes of the exemption. Next slide, please. There is no New York salary threshold for the professional exemption, and that's not going to change for the new year. Remember that the federal threshold for all of the white-collar exemptions, the executive, administrative, and professional, is $684 per week. That amount is exclusive of board, lodging, or other facilities. So if you're going to consider a person to be exempt, they have to meet the $684 exclusive of board, lodging, or other facilities, and they have to meet the new threshold if they're an executive or administrative under New York law, inclusive of board, lodging, or other facilities. We are expecting really any week now, or possibly even any day now, that the US Department of Labor is going to issue a proposed rule increasing the federal threshold. So stay on the lookout for that. If you remember, a number of years ago, there was a proposal to increase the federal threshold, which was struck down by the courts and then later withdrawn. They are expected to reintroduce that rule very soon. There is no federal salary level requirement for certain types of occupations, such as teachers, doctors, lawyers, or medical interns or residents. Next slide, please. One of the other developments that's significant that again has limited applicability, but it's important to note, is that the New York is trying to phase out the agricultural overtime exemption. Under federal law, there's an overtime exemption for agricultural workers. New York has passed a regulation that says that it's going to gradually phase out. So effective January 1st, 2024, Farm workers are going to be entitled to overtime at a wage rate of 1.5 times the employee's regular rate for hours worked in excess of 56. And then it's going to keep going down every 2 years in 4-hour increments until by January 1st, 2032. All farm workers are going to be entitled to overtime pay for hours worked over 40 in a work week. That's it. That's all I have. I'm going to turn it back to Adam.
So Suba, we did get one question during your presentation about the increase in salary levels for administrative and executive employees. How certain are we that that is actually going to be increased?
I would say 99% certain. It's going to be that or around that.
All right, and I thank you, Suba. All great information. I'd encourage everyone to ask questions if you have them, because we will try to get to them during the presentation. All right, next up, we have Nick Jacobson to talk about New York's revised gun law and a court decision from last week that significantly alters the enforceability of that new gun law. So Nick, you presented on this, I want to say a couple months ago on the webinar. And you're here to give us this update, which I don't think is all that surprising, because I think you said during the webinar that you wouldn't be surprised if there were some legal challenges to it, and here we are.
Yep, here we are as expected. Next slide, please. Yeah, so as you may recall from my last presentation, those of you that were on it, since 1911, New York has prohibited the unlicensed possession of firearms. And until recently, for individuals to be able to conceal and carry a firearm outside their home or business, they were required to demonstrate proper cause for them to have such a license. Next slide, please. The proper cause requirement required applicants to demonstrate a special need for self-protection that was different from that of members of the general public. Really, it required applicants to show a specific threat personal to them. Things like living in a bad neighborhood or a high crime area were not sufficient to meet that proper cause standard. And without meeting that proper cause standard, you were only able to get a restricted license, allowing you to carry a firearm publicly for purposes of hunting, target shooting, or employment. Next slide, please. That law was recently challenged, and the United States Supreme Court held that the proper cause standard was an unconstitutional restriction on individual Second Amendment rights. And New York kind of had to go back to the drawing board with their gun legislation. Next slide, please. What they came up with was the Concealed Carry Improvement Act. It was passed and then signed into law by Governor Hochul on July 1st of this year. It replaces the proper cause standard with a requirement that applicants demonstrate that they are of good moral character, which was always something that was likely to be subject to constitutional challenge. It also required applicants to provide character references and information regarding family members and social media accounts. And it imposed a training requirement requiring applicants to undergo 18 hours of firearm safety training and to participate in an in-person meeting to obtain a concealed carry license. Next slide, please. The Concealed Carry Improvement Act also prohibited the possession of firearms in sensitive locations and restricted areas. Sensitive locations included things like government buildings, healthcare facilities, religious institutions, casinos, libraries, public parks, places of entertainment, places where alcohol can be served, and public transportation. Restricted areas, the definition was much more broad, and it defined restricted areas as private property where the owner or lessee had not posted clear and conspicuous signage or otherwise explicitly or that otherwise explicitly given permission for individuals on the property to possess firearms. Next slide, please. So as expected, the CCIA was subject to constitutional challenge almost immediately after becoming effective on September 1st. And Judge Glenn T. Sotheby of the Northern District of New York in Syracuse issued a decision restraining enforcement of significant portions of the new legislation last Thursday. Next slide, please. So Judge Sotheby, in his decision, restrained enforcement of the good moral character requirement and ordered that it be enforced such that licenses are to be issued unless a preponderance of the evidence demonstrates that the applicant lacks good moral character and that their possession of a firearm would pose a danger to themselves or to others. Judge Sotheby also restrained enforcement of the provisions requiring that applicants provide information regarding their relatives and cohabitants, as well as their social media accounts. And he also restrained enforcement of the provision requiring an in-person meeting to obtain a conceal and carry license. Most importantly for employers and business owners, Judge Sotheby also restrained prohibition on firearms in restricted areas. He stated in his decision that the law took away property owners' decision-making power in the matter and arguably compelled them to engage in speech on a sensitive issue by either, if they wish to allow firearms on the property, to take the step to put up signage or promulgate policies prohibiting the possession of firearms. Next slide, please. For now, the provisions requiring the 18-hour firearm training requirement and the character references were allowed to stand. Next slide, please. With sensitive locations, we got a split decision, with Judge Sotheby holding that the prohibition could stand with respect to certain locations defined in the law as sensitive locations, while restraining the enforcement as it applied to other locations. Judge Sotheby held that the provision could stand for now as it applied to government buildings, places of worship or religious observance, except to the extent that individuals present had been charged with keeping the peace in those locations. He also held that it could stand with respect to schools, colleges, and educational facilities, except as it applies to summer camps. And he also held that it could stand as it applied to gatherings of individuals who were expressing their right to protest or assemble. Conversely, he restrained application of the law as it applied to prohibit the possession of firearms in places or vehicles used for public transportation, places of entertainment, amusement, or where alcohol is served, Times Square, which was specifically identified in the law, and the other sensitive locations the law identified. Next slide, please. So where does that leave employers? Further developments are coming. Kathy, one click, please. And what that means for employers is that you're going to have to stay tuned. Judge Sotheby stayed enforcement of his decision for 3 business days to allow New York State to seek emergency relief from the Second Circuit Court of Appeals. New York has already done that. They filed papers with the Second Circuit yesterday afternoon, and they've requested an interim stay be issued by the end of today to prevent Judge Sotheby's ruling from taking effect and giving more time for the Second Circuit to issue a full decision. Next slide, please. So what does that mean for employers and businesses? Unless you are otherwise a sensitive location where the prohibition on firearms was allowed to stand, we're back to a post-Bruin, pre-CCIA world, which means that the possession of firearms is not presumptively prohibited on private property simply because the owner or lessee has not given explicit permission. Instead, businesses and employers should consider posting signs and implementing policies regarding the possession of firearms if they wish to restrict possession on their property. And a shameless plug for our labor blog and these webinars. Stay tuned for further updates because I'm sure they're coming in the near future.
Nick, that is very helpful. I know a lot of our clients were confused when this law was first passed because the way that it's written, if they don't put up a sign saying that firearms are explicitly allowed, then they would be, presumptively illegal. So I knew it caused a lot of confusion. Judge Sotheby's decision, unfortunately, I think causes some more confusion. So we are going to have to wait to see what this, what the courts do with this. Ultimately, this may end up at the Supreme Court, and the Supreme Court may have to rule.
Yeah, I think that's likely that it'll end up at the Supreme Court.
Yeah. All right, Nick. Well, thank you, and stay tuned for further updates. Okay, next up, I have the pleasure of introducing our recurring panelists, Lou DiLorenzo and Jeff Keel, who are going to give us some helpful tips for workplace investigations. And this is going to be an interesting presentation because it is based on cases that both Lou and Jeff have actually had, and how people have tried to critique workplace investigations that were done by employers. So Jeff and Lou, welcome. And I'm curious to hear what you have to say here.
Okay. Well, thank you, Adam, and good afternoon, Lou. Lou, I don't want to talk about how to do a workplace investigation. I'd like to talk about how not to do it. Would that be okay?
Sure.
And the reason for talking about how not to do it is when you have done a workplace investigation, it is much more likely than not that it is going to be scrutinized by an external agency or a court. Now, there are reasons for doing internal workplace investigations simply to find out what happened. But you have to go about this considering the very strong possibility that whatever the complaint was that led to that investigation is going to ripen into an agency complaint or a litigation in court. And when that happens, here's what you're going to be looking at. First off, judges and administrative agencies see lots and lots of investigative results. And they actually do have checklists for determining whether an investigation has been properly conducted. And if it has been properly conducted, it can be a defense to a claim that an employer did not act to remedy a situation. If it's been improperly conducted, it can lead to liability. More than that, there is now an entire industry of expert witnesses whose job it is to testify in court about whether or not a workplace investigation was properly conducted. So, Lou, let's talk about the list of mistakes we don't want to make when we have to go about this.
Okay, Jeff, great presentation. So one of the things we also have to think about is what's the purpose of the investigation you're doing? Is it a legal requirement because we got a discrimination or a harassment complaint? Or is it just investigating general misconduct? Different issues arise. Labor contracts typically have a just cause standard. So we're going to use that investigation to prove we had just cause. In the discrimination harassment context, it's probably going to be a sword or a shield against liability. If we find something wrong and we take corrective action promptly, we may have a defense to the liability if it's occurred. And if it hasn't occurred, that finding hopefully will be a shield. But oftentimes it's a sword, sometimes it's a shield. First mistake, Jeff, that we see on a too frequent basis is a failure to plan the investigation. And I think part of that is because everybody's so busy. I mean, it's a real added burden to an HR office to have to conduct an investigation. They're time consuming. But you got to plan this out. You got to make the time to do it promptly, and you have to plan out how you're going to do it. Who's going to do the investigating? What order? Who's going to be interviewed? What documents are we going to gather? What order are we going to do the witnesses? All those things have to go into the planning of the investigation. Now, like Mike Tyson says, after the first punch, the plans oftentimes go out the window, and that may happen in your investigation. But if that happens, we're going to replan it. and make a corrective course and go on. We're going to go back to people. We're not going to check Lou DiLorenzo off our list. I already interviewed Lou. If things come up in subsequent investigations or interviews, we may go back to Lou to check on some of the things that he said, or something that was said becomes very critical, and we want to go back and make sure we do it. So planning it, Jeff, I think is the first thing we want to make sure we do. And those that don't plan are pretty much perhaps doomed to failure. So you want to have a good plan. Jeff, what do you think is next?
And also, in terms of planning interviews, think about what information you want before you conduct the interview. You may want to see a personnel file. If there's a written complaint, you certainly want to see that. If the complaint involves social media postings, you'd like to ask for copies. If it's an area of the workplace where there is surveillance video for security purposes, you may want to look at it, because the more you know when you conduct an interview, the more useful information you'll get. But let's move to the second.
Actually, Jeff, even along those lines, as before we plan, you reminded me, we want to make sure we have a still target on what the allegations are from the complainant. Now, it's illegal under the EOC guidelines, if you have a complaint covered in the discrimination area, to insist that there be an affidavit or the complaint be given in writing. You can't do that. It's nice to get it in writing. If the person doesn't want to give it to you in writing, they're concerned about defamation or something else coming back to haunt them, they don't want to give it to you in writing. Take good notes and send a confirming email or some process by which we say, look, I interviewed you yesterday. These are the things you told me. Could you take a look at this? Confirm for me that I've captured everything you told me. I haven't left anything out. The reason for that is I've seen investigations where months after they're done and the lawsuit starts, somebody says, well, I told you in that first meeting, I told my HR director in that first meeting that this guy touched me in a sexual manner. And there was never any allegation of physical touching, which changes the direction and the seriousness of a sexual harassment investigation, for example. So we want to lock people in to the allegations and then start planning how we're going to address it. Sorry to interrupt, Jeff. Go ahead.
Okay, now the second big mistake that happens is finding that an employer has ignored a complaint. Now, I know that when we're talking to an audience which is largely lawyers and HR professionals, that sounds like something that's pretty obvious. But in fact, one of the things we've learned over time is that people tend to ignore what is inconvenient to acknowledge. That is how you get to all of the sexual abuse scandals in college sports. Known for years, ignored because it would have been inconvenient to deal with them. It's not, now obviously, if a complaint comes in, you can't ignore it. But you also need to create a culture where those complaints are not ignored. And if, in fact, the allegation is that a complaint was made and had been ignored earlier, you're going to have to look at it. And you're going to have to figure out whether that is, in fact, the case. So while it sounds obvious, just remember, human nature is such that people want to ignore what would be inconvenient for them to acknowledge. And you just have to swim against that stream. Lou.
Yeah, and Jeff, I'd add to that the fact that you mentioned it when you said create a culture where we're accepting and welcoming of complaints. And that requires that you train your supervisors and managers. They have to understand that we want the complaint. We want to handle it ourselves. We don't want people going to a plaintiff's class action attorney or perhaps even a union if we're interested in remaining union free. We want to handle the complaint, so it's got to be a welcoming atmosphere. Supervisors and managers have to understand their role in the organization and the fact that they are the face of the organization to the employees. I always think it'd be great by the time they get to my desk or Jeff's or Adam's or Suba's. I always wonder if there's a correlation between how that first meeting with a supervisor was handled versus whether it ends up being a complaint that has come to our attention and it becomes expensive to handle. And maybe a third party is going to structure the resolution for us instead of ourselves. So we always want that to happen, and our supervisors and managers have to understand that. It's not a bad thing for them to get a complaint in their department and to bring it to HR's attention. The other thing that goes hand in hand with ignoring them is delaying them. And I'll be honest with you, oftentimes in the litigation that we get, it's because it's been delayed by the investigators. People are on vacation, HR offices are overworked. We've got to make time to do this. It's got to be done promptly. All kinds of problems are associated with it being delayed. There can be additional victims. There can be allegations that it was delayed. We didn't take it seriously. We didn't comply with our obligation, conduct a thorough investigation promptly, and take corrective action if it's needed. It must be done quickly, not hastily, but quickly with all deliberate speed. Jeff.
Okay. Another area, and we see this in several different respects. I'll start with one of them, is losing objectivity in conducting an investigation. And you will see this particularly where an expert witness has challenged an employer's investigation in court or before an agency. Now, some of it is obvious. The boss was investigated by his subordinate, whose job conditions the boss controlled. Well, that's not objective. The employee was investigated by his brother-in-law. And that could cut either way, I suppose, in terms of objectivity, but it's going to create some questions. You'll get into a lot of corollaries. The interviews were done in an offhand manner. The employee was blown away during the interviews. But I want to talk about something else, which is really the step back we need to take in doing this. And Adam, if we can have that slide, we finally do have a slide for our audience on confirmation bias. Can we get that up there?
Took a lot of time for us to develop it too.
Adam, is that up?
I don't know if we have it, Jeff. I apologize.
Okay, it was in the PowerPoint that you sent to Kathy, I believe.
Yeah, we'll have it for everyone to see when it gets
Okay,
sent
when
out
it
tomorrow,
gets
for
up,
sure.
let me
Yeah.
tell you what confirmation bias. Confirmation bias is the very human tendency to see what you expect to see. And you have to step back from what you expect to see. Our little Venn diagram is wonderful, but I'm going to give you an example which works almost as well. Years ago, I got a call from an HR manager with whom I had worked for a long time and whose judgment I trusted, who told me that we had had a complaint from an employee, we will call her Mindy, about her boss, whom we'll call Dwayne. And I was forwarded the complaint. It was a letter from a little two-lawyer shop. It wasn't terribly well written, but basically it said that Dwayne had repeatedly sexually harassed Mindy. So I talked to the HR manager about it. We actually knew quite a bit about Mindy. She'd been employed for a number of years. She was a problematic employee. She had a terrible absence record. She had a terrible tardiness record. She had been implicated in some expense account abuse. She had had interpersonal conflicts with lots of other people in the workplace. She was known to be a gossip. She had a reputation for generally being a liar. And Dwayne, her boss, categorically denied that he had done anything, and that, in fact, this was simply because she thought that her job was in jeopardy and she was trying to buy herself some safety. And by the way, we've all seen stuff like that in the past. So I did some investigation and I said, look, this is pretty much a slam dunk. And I wrote my standard Force 5 letter back to the lawyer saying, listen, we've looked into this. We don't believe that there's anything to it. We're sorry, but you're just going to have to go away. And as was my custom, I finished that letter with the following line. If, however, there is anything you think we have misunderstood or overlooked, please feel free to contact me, which was basically my way of politely blowing off the complaint. About 2 days later, I got a call from one of the two lawyers who said, were you serious about that? I said, yeah, I guess I was. Well, what would you like to see? Would you like to see the pornographic comic book that Dwayne gave Mindy? Would you like to see the pornographic birthday card he sent her? Or would you like to see the handwritten note which he signed, which said, my darling Mindy, I long to take you in my arms and make the world go away. Now you know this is a real case because I couldn't make that up. And I said, yeah, I would really like to see that stuff. and I had it by Federal Express the next morning. I had engaged in a classic case of confirmation bias. The complaining employee looked like a wacko. She walked like a wacko. She had a terrible reputation. Reasonable people whom I knew thought that this was a baseless complaint. And I was all set to blow it off on that basis, but for the fortunate fact that I had that last line, if there's anything that you think I've overlooked or misunderstood, please let me know. That's what confirmation bias is. You need to step back. Lou, do you want to comment on that or move on? You're muted, Lou.
The only thing I'll say, great point, Jeff, and I'll just say that those kinds of, that kind of a mistake is one of the most costly we get in this case, because we go down a path that ends up being very, very costly. By the time we realize our mistakes during discovery, it's become a very expensive case. It's something that could have been addressed early on and perhaps totally avoided any litigation at all. Next one I'm going to talk about is sometimes there's distraction during the interviews. The interviews that are conducted are incomplete, sketchy. You got to think in your planning of the investigation, think about how you're going to do that. You should have a couple of people in the interviews. So we have another witness. One should be a note taker. One should be a questioner. Sometimes people, depending on the case, sometimes people produce Xerox copies of the questions, and they leave a space for the answers, which the note taker fills in. So a couple of things happen there. We have a procedure. We don't miss any of the questions. People pretty much get asked the same questions if they're relevant interviewees, and it's a process. And we don't get distracted during interviews with other meetings or calls. We have a place where we interview people, and it gets done. And again, it gets done quickly. We got to get it done quickly, and we see the issues that require us to go back to some people to get more information. So again, this is more blocking, tackling, basic interviewing techniques. Make sure we get the information down, make sure we're not distracted, make sure it's complete, make sure we can prove everything we've done. That kind of an issue. We see that sometimes in mistakes. And these experts that Jeff are talking about, they want to go over those notes, the report in detail. Remember, there's a bunch of people trying to second guess your interview. You know, I'll tell you one quick story. My parents are both from Italy, Italian immigrants. My mother, as she got older and lived alone after my dad died, I'd stop and see her when I was in her neck of the woods. And she always wanted to hear about the cases. And whenever I told her we had an investigation going on, she'd say in broken English, well, what does the DNA evidence show? And, you know, I used to laugh and say, Mom, we don't have DNA evidence. We don't have a laboratory. We're not a police department. Two things I learned from that comment from her. One is she's watching too much television. Two, this is the way lay people think about when the judge informs a jury. I always get a chill down my spine when the judge says to the jury, you have to decide whether an investigation was done and whether it was a proper investigation. Lay people, similar to my mother, think about the investigations they see on television. They have a pretty high standard of what an investigation is, as opposed to what we might think of an investigation. Well, they talked to somebody, they investigated it, the legal standard is low. Well, lay people think it's a little bit more than that. So we want to be complete. We want to, you know, make sure all the corners are nice and tight and do a good job on the investigation so we can defend it. Jeff.
Well, before you two move on, we got a question I think I want to pose to you both. We got a question from somebody on. What are your thoughts on recording interviews?
That's a good question.
Yeah, I don't like it.
Yeah, I don't like it either. But there have been times where I've suggested we do it. The stakes were so high. We knew that people that were going to be our adversaries were uncooperative. We knew they were going to be evasive in the investigation. And frankly, I wanted it on tape. I always recommend taping if the other side has a tape recorder. And that's one of the questions we should ask. Is anyone taping this? If they say yes, or they put the tape recorder on the table, I would let them tape it. I would bring my own tape recorder in so we have a duplicate of what happens in the meeting and nobody can mess with it. But generally, I agree with Jeff. I don't like it. I think it intimidates people. They're afraid. You may get less information instead of more, but there may be some interviews or maybe some cases where it may be an option that you want to pursue.
Yeah, I agree with Lou on that point. I think it is off-putting to a lot of witnesses unless there's a compelling reason. You know, it also used to be that insurance investigators would conduct an interview and then they would ask the interviewee to write on a piece of paper with no margins, from margin to margin, exactly what happened. And I always thought that that was a particularly non-helpful tactic. I will say this, though. Having conducted many, many interviews where for various reasons I was the only person present, yes, I would have an outline. Yes, I would often have my questions written out in advance if for no other reason that you want to question people in a consistent manner within the same investigation. But you know, you can't stop and take extensive notes. So at the end of an interview, I would have a bunch of chicken tracks in my memories. If that is the case, that afternoon or that night, write down everything you can remember, because those chicken tracks will jog your memory. It will give you the exact thing that somebody said. And if you're not sure at the time, and this will lead perfectly to our next don't do it, you may want to say in an interview, let me be sure that I understand what you're telling me. Are you saying, and then don't be cute. Try to recapitulate exactly what the witness did say and make sure you got it right. Because another mistake that is often made in investigations is coming on like an avenging angel or the DA in Law and Order, cross-examining a recalcitrant witness. That is going to get you exactly nowhere in an investigation other than really to antagonize just about everybody you're talking to. The purpose of the investigation is to get facts. And one of the ways of getting facts is to get people to talk to you. So have a relaxed manner. And what I generally do is try to play dumb, which comes to me quite naturally. I will say, help me to understand what happened here. I need to understand, what did that hallway and that office look like? I'm not quite sure I understood that. Can you clarify it a little bit? Can you be a human video camera for me? You say that this encounter happened when you met at the water cooler. Can you tell me what you saw as you walked to the water cooler? And then what did she say when you got there? Now, what does this do for you? It gets the witness relaxed, so you're going to get information. You may get information which is very helpful. And if you're interviewing the complainant, it may be helpful in the sense that it contradicts the complainant's claim. It may also tell you that something serious happened that you're going to have to deal with. But it also goes to an essential part of the truth-finding process. There's a wonderful book for litigators called Wellman on the Art of Cross-Examination. And it talks extensively about how you distinguish the truth from a lie. The truth has a web of surrounding and corroborating facts, and a lie does not. So if Mindy's claim had been that on a business trip to Cincinnati, Dwayne, after dinner, walked her back to her room and tried to push his way into her hotel room, I'm going to be interested in a lot of stuff. And one of the things I'm going to want to know is what that corridor looked like, where they had dinner and what it looked like, and quite frankly, what the weather in Cincinnati was that day. Because if in fact all these things happened, that's all information that Mindy would know. When Mindy has to start outliving it, I am now getting the handles that let me reach the accurate conclusion that it wasn't truthful. So don't come down on the witness. Use the interview as an opportunity to learn things. Very important. Lou?
Jeff, why don't I wrap up here with the last couple that we were going to cover, because I think we've kind of done them. Jeff was talking about taking those notes, those chicken scratches, as he called them. So think about that process, right? There's nothing better than when I have a witness on the stand and they did all their chicken scratchings, and we still have those, even though they typed up a nice report that reached a conclusion, made credibility determinations, and They get cross-examined on their original notes. And the accusation is this report's not accurate. That's not what people said, or that's not what the complainant said, or that's not what happened. And we have the original notes, which we can put up on a board side by side and show how that afternoon, when they were transcribed, those original notes taken in real time match up with what was typed later. Although the thoughts are much more complete, the kernel of the origin of the thought was in the notes. A lot of people will destroy those original notes, and we're left with a beautiful typed report that was done 20 days later, according to the forensic computer guy. But we don't have the underlying notes. So the plaintiffs are able to argue they manufactured this report in the 20 days they had since they did the interview. So we want those notes. Keep those notes. And think about it as you transcribe them and take your material from the notes. And we have to reach a conclusion. It's important, I think, in most cases to have some kind of report. There are times where we don't advise a report, but those are the exceptions. Generally, a report is good. You did the investigation. We want to stand by it. My mother expects there to be an investigative report with a cover on it that looks like a real report, right? We'll put a plastic cover on it. We'll make it look good. We need something that concludes this investigation. And if there's credibility determinations, don't be afraid to make them. Something. I believe this person for the reasons that Jeff said. There's some corroboration or lack of corroboration on this person. I don't believe them, or it is virtually impossible to determine. But those are few and far between. The he said, she said case don't automatically trigger he said, she said, I don't know who to believe. There may be easily somebody we can believe in this mess. So what you rely on for credibility, you should put in the report so the reader, the jury, the decision maker, the human rights investigator, whoever's looking at it can say, I understand why they believe this person over that person. Remember, in a discrimination case, for example, we don't have to be perfect. We don't have to be right when we say I fired this person because I did an investigation and I believe they stole money from us. You don't have to be right. All we have to do is have a reasonable basis in a non-discriminatory reason. I thought the guy was a thief, so I fired him. That's all you need. And what you need to prove you had a reasonable basis is that investigation and the report. You may even work for just cause. Again, just cause is not proof beyond a reasonable doubt. It's just cause to believe that there was reason to terminate the person. So dot those I's, cross those T's, and be careful out there when you do investigations.
All right, quick follow-ups. Jeff, what was the name of the book? Someone asked.
Wellman on the Art of Cross-Examination. It was written about the 1930s.
Francis, I think, A. Wellman. It's a terrific book.
It is not, it's a book for lawyers, but it is a great book. It has war stories of the court in the courtroom, which are absolutely marvelous.
It is.
And which you'll never forget. I particularly recommend to anyone who reads it, the chapter on circumstantial evidence and why it is often more compelling than direct eyewitness evidence.
Okay, question 2. Someone asked how they can view this video. It will be emailed to you and you can watch it. It's also available. I believe we have a YouTube page where all of our webinars are available. So thank you again, everyone. Great to see you. We'll see you again next week.